Trademarks. All you need to know about trademarks if you only knew what to ask. There are 5 crucial points to know about trademarks that might change your entire approach to branding and trademarking. So I'll start by answering the question, what is a trademark? Trademarks are signs used in business to identify products and services in the marketplace. So customers can find you by recognizing your unique sign identifiers and avoid confusing other providers for you. You might have a variety of identifiers, your name, logo, tagline being the typical ones. The single most common one that people would recognize you by, though, especially if they look for you online, is your name. So if you have delivered a good and effective service and customers want to buy from you again or refer their friends and family to you, the unique identifier they would use to do so will be your name. Often not your own personal name, but your business name or brand name. A trademark is a device or tool created by the law that enables consumers to find the products and services that they're interested in. It's a container of your brand signs, such as your brand name. Trademarks serve this purpose of being your badge of origin. They're designed to avoid customer confusion, which is why a trademark has to be able to function as a unique identifier of your products and services. A trademark, therefore, tends to be a most valuable asset as you build goodwill. However, not all signs qualify for exclusive ownership as trademarks. Names that don't qualify as a trademark. Now, say you provide IT support services and call your business IT support. You won't be able to stop another IT support business also referring to themselves as IT support. The law will not give anyone exclusive rights to use a term like IT support, which all other traders in the industry need to be able to freely use. So if you use a sign like that, which the law will not give you exclusive rights to, for example, because the sign is too descriptive and not capable of functioning as a trademark, it means you don't have a unique identifier. Effectively, it's like not having a name. Your competitors will therefore be able to use the same sign or similar signs and steal some of your market share. They'll get business that might have been looking for you. As such, it's like having a leaky colander rather than a leak-proof container for your brand. As such, it means your brand value will be reduced. It will be less than it might otherwise have been. Consumers will be confused when they're looking for your products and services. Say you register IT support with a logo. You will secure a trademark registration, yes. However, what you're essentially getting protection over is the logo, not the name. The law will not accept IT support as functioning as a trademark, so the name element won't be exclusive to your business. Competitors would also be able to use IT support as a name to identify their business. You see, as the name is such an important identifier, it's really important to make sure your name is one that is capable of functioning as a trademark. Otherwise, your trademark registration isn't going to give you the unique rights over the name element of your trademark that you need. You will end up with customer confusion in the marketplace, and this will reduce your profitability as a business. On the other hand, if you choose a good name that can uniquely belong to you, it will protect you even if someone is simply using a similar name that could be confused with yours by, the market. A name that can't function as a trademark won't even protect you against exactly the same name being used by a competitor. Buyers are not going to be so aware of the look of your logo if they've heard of your business from their friends and family as to be able to immediately recognize from the logo on the website that it's not actually your business but that of a competitor. So don't be lulled into a false sense of security by a logo trademark registration. Remember that the primary benefit of a trademark should be to enable you to challenge others who use similar names. For an IT support business, a better choice of name would be Geek Squad. However, there can only be one Geek Squad. If someone else is already using the name in the country in which you're operating and has registered as a trademark, you should avoid choosing that name, and indeed any name that's similar to it. Otherwise, you'd be infringing on the trademark rights of the earlier mark. From this, it follows that once you have chosen a name, you must check that it's available to use before adopting it. So legal effectiveness and availability are keys to trademarks. Domain and company names need to be checked before use too, but it's trademarks that govern rights in names. The fact that a domain name or company name is available to register doesn't mean you can just use the name for any purpose you like. You must only use the name for purposes which don't conflict with third parties' existing trademark rights. This brings me to the next important aspect of trademarks that you should be aware of, and that is trademark classes. How trademark classifications work is this. Trademarks are registered by reference to specific classes or business categories. So you need to think through your plans and identify the business categories that are relevant to your type of business, and then search and register your mark in those categories. Under trademark law, names may be shared. So if your desired name is already registered, but for different business activities, you may still be able to use that mark and coexist with another business who is using the same name for their different purposes. For example, Automobile Association and American Airlines are both known as AA and are both registered trademarks in the same class. Similarly, Polo is registered by 3 different businesses who use the name for a car, confectionery, and clothing. Another example is Delta, which is used both as a brand name for airlines and for kitchen appliances. Dove is a brand of personal care products, but it's also a brand of chocolate. The takeaways from this is to identify the trademark classes applicable for your brand when searching and drafting your trademark. The classifications determine the scope of protection you get. You should seek the widest scope of protection necessary to avoid having someone else build up rights to use a brand sign in the business categories that you may need down the line. Say you register your name to sell clothing and then later decide to also sell cosmetics. If someone else is using a similar name to yours for cosmetics, you might infringe their rights by extending your activities to encompass cosmetics, meaning you would need to find a different name for your cosmetics line. So don't ever assume you may just go ahead and use your name for any business activity you like. First, check whether you've registered the name for that business category. cosmetics in this example, and if not, do a search and register in the new business category before embarking on the new use of your name. So why register a trademark is the third point to consider about trademark trademark registration. Trademarks are an essential step to securing the exclusive rights that your business needs over elements of your brand identity. It's also the way to retain your brand's distinctiveness and avoid seeing it become generic. Registering a trademark is the formality you need to go through to secure ownership over your brand sign. As already mentioned, prioritize the name because it's the primary way people will identify you. A trademark enables you to stop others using the same mark. By having a registration in place, others are on notice of your rights. So provided you've checked that you can use the name before you register it, you get exclusive rights over the name in the business categories in which you register your mark. It's important to understand proper searches because jurisdictions like the EU, registration doesn't protect you against infringement. For example, SkyDrive was a registered trademark of Microsoft, but wasn't enough to prevent them infringing on Sky's trademark rights. Sky took the matter to court, arguing that the names were confusingly similar for cloud services, and the court agreed with Sky, so Microsoft was forced to rebrand to OneDrive. Some countries, such as Spain, require names to be registered as the rights in names are based on who first registers a name rather than who uses it first. In common law countries, using a mark without registering it does give the user certain rights, but they're a lot more limited and costly to enforce than most people realize. If you don't register your trademark, you risk losing uniqueness. Something that started out initially as distinctive to your brand can quickly become generic. Had Coca-Cola not protected its iconic bottle from the outset when the bottle was designed for the company, there is no way the bottle would today be uniquely associated with their brand. You see, a case that demonstrates how precarious it is to rely on use of a mark involved two bands that were called Blue. This was a while ago. So they were two bands. One was a current boy band backed by EMI, and the other was a 70s rock band. The band had a single released in 1977, and which reached number 18 in the charts. They also had several albums, remixes and such like, but they hadn't registered a trademark, and as a result they weren't able to stop the new boy band Blue from using the name. Now, trademarks are cheap to register and expensive to enforce when you haven't registered one. The advantage of registering a trademark is significant. Registration considerably reduces the risk of other people picking the same brand element for their new products and services, because your registration is on the public trademark registers. People are expected to search these registers before choosing names or other brand elements. So if you're not on the registers, someone else may build rights over the same name or other brand element, and this can lead to messy disputes, as it did for the band Blue, and unnecessary costs. So basically, they would be in the wrong if they have used a name where you've already registered your rights, and therefore it would be a lot cheaper for you to enforce your rights. International trademarks is the fourth point I want to mention about trademarks. They are territorial trademarks, which means you need to apply to register a trademark in every country in which you want to trade and receive protection. There is no such thing as an international trademark. There is an international mechanism in place to apply for trademarks, which make applying for trademarks in a number of countries simpler to achieve. It involves filing an application in your home country first, and then, thanks to various international agreements between countries worldwide, you get 6 months protection from the date you first file your first application, if you then file an application under the Madrid system. You're then able to extend that base home country application to countries who are party to the system. You simply file a single application and designate your desired countries and pay the applicable fees. Unfortunately, if you don't protect your mark in countries in which you trade, you could find yourself in situations similar to what happened in Plenty of Fish, Plenty More Fish. Plenty of Fish was a well-known established online dating site, but it objected to Plenty of Fish, More Fish setting up in the UK under a similar name. They opposed Plenty More Fish's UK application, arguing that the company was riding off their reputation by setting up a rival site. But they couldn't show that they had enough UK customers, and therefore, because they hadn't protected their brand as an EU trademark, they were powerless to stop Plenty More Fish. Now, this sort of situation would never happen within a country, because passing off laws and other remedies in local trademarks would prevent such a scenario arising. However, online, it's possible for this sort of scenario to arise unless you're vigilant about protecting your mark in countries in which you trade. Better to cover off your home market and the important jurisdictions in which you trade. Prioritize registering in countries in which you do business first. The fact that trademarks are territorial means your registration only protects you in the UK or EU or wherever you've registered. A UK trademark registration covers the UK only, while an EU trademark currently covers all 28 European countries under a single application, including the UK. However, once the UK leaves, with Brexit kicking in, then an EU mark will no longer include the UK. So you should be considering your strategy carefully if you're registering your mark now. It is possible to extend your home country registration to other countries that are not party to the Madrid Protocol by filing directly in that country. At the time of writing, important countries that are not party to the Madrid include Hong Kong, South Africa, and Canada. You don't need to be a household name or huge multinational to aspire to be a brand in the sense of becoming recognized provider of products and services you sell. Your brand protection is important. Oppositions and objections are the last point I want to discuss, because they do occur from time to time. And, people are sometimes caught out by them. You see, the trademark process involves a review by the trademark examiners of the registry to which you apply for your trademark. They may have some objections. Typically, the objections might say that the trademark isn't properly applied for, or they might do a search and reveal that other people have similar marks and so on. Now, if you don't understand the examiner's objections, people tend to just abandon their applications. So if you're filing your own application, make sure you've got a resource you can turn to for advice if there are objections to your application, as they're often quite simple to address. Once any objections are dealt with and your application is approved, it's advertised for what is known as opposition purposes. That's when existing trademark owners will be alerted to your applications that are similar to their registrations so that they can consider whether they want to oppose. Either the IP office notifies them if they have trademark watch services, though they may hear from their trademark agents. They may not necessarily bother to oppose applications. In the UK, that doesn't stop them objecting to a registration several years later. Indeed, they often don't oppose a startup and wait to see whether the startup succeeds before deciding to do so. The single most valuable information that could literally save some businesses from catastrophic results is to learn from the mistakes of Scrabulous. Now, this was a very successful app on Facebook that provided a Scrabble-like game online. It had hundreds of thousands of users when it was stopped overnight by trademark and copyright infringement claims. The business came to the attention of Hasbro, the owners of Scrabble, because they filed their own trademark application, and Hasbro was notified. Hasbro considered that the company was infringing on its brand by using a similar name and were also infringing copyright in their board game. Hasbro applied to Facebook to have the app taken down. Facebook immediately complied, so the company lost its successful business on Facebook virtually overnight. The setback paved the way for Zynga to enter the market with what is now the leader, Words with Friends. Scrabulous lost its position as first in the market. So the teaching point here is to get an opinion from a good trademark lawyer before filing an application, as the application itself will alert others to your activities. Had Scrabulous sought my advice, I would have counseled them to quietly rebrand rather than apply for a trademark, which was bound to bring their infringement to a head. You see, you can rebrand to new names without any loss of goodwill because you're able to redirect everyone to your new name. However, when you're required to rebrand due to a trademark infringement claim, you lose all the value that you've built up in the name. You lose all your brand value that you'd built up, and the terms of infringement undertakings typically require you not to repoint traffic and not to tell people you've changed your name. Much better for a business like Scrabulous to have quietly rebranded to a new name and never come to the attention of Hasbro. They would still be the market leader probably today had they done that. The moral of the tale is not to be cavalier about the names you get to, and not to get too attached to a name that you can't legitimately lay claim to. It's possible to choose a better name, another name. You need to get an opinion on the name that you're using. A wider lesson from the above is that if you're running a business where you don't think a buyer of your business will want to use your name, that doesn't mean you need not protect your name or need not bother to make sure that you're using a good trademarkable name. You see, your market share is what a trademark protects. If you're forced to rebrand and you can't keep the value you had generated and effectively vanish overnight, it's like being back to square one with a totally new name, new business. Nobody knows who you are.